Hello and welcome to Chapter 47. This chapter is about professional liability and accountability, and it really focuses just upon two professionals, and those are the ones that I guess is fair to say are the most involved in the business world, and after all, this is a business law class. So there's surely professional accountability in other fields, such as the medical field, but we're not going to talk about a doctor having liability here. We're going to focus on the two professionals that are the closest to the business world and are most interwoven with them. And those two are going to be obviously attorneys and accountants. So this chapter is an interplay between these two. It moves back and forth between those two groups. It's fairly technical. I don't tend to ask a lot of questions on the quizzes or finals about this. You won't even have really a mention of it. We're going to go over it. But I don't assign work from it, really, because this is more for you to be informed if you're dealing with an accountant or an attorney, what to kind of look for if you feel, well, there's been an error and maybe I should be able to pursue some sort of legal remedy. Or maybe I shouldn't. And this chapter more points that out. So even though I'm going to talk about some fairly technical stuff, and I'm also going to introduce some specifics to North Carolina, just be aware that this will not be hit very hard at all on the final or on work that we do. Oops. Okay. So the first idea really to start with here is that there are three basic causes of action for suing an attorney or an accountant, and there are others, but these are the basics. And these would probably be present in almost all cases. Again, to review, when I say cause of action, that's a legal term that really means that you have the authority to go ahead and sue under the law. You can have a case where you have suffered an injury, but there is no legal recourse to sue. So sometimes, for example, someone is injured by the state or by the federal government or in the service of the country, and because of doctrines like sovereign immunity, there is no legal cause of action under which you can sue, or you can't state an injury, so you can't sue. So it's important to focus on these three areas, breach of contract, negligence, and fraud, because those three areas really are where almost all cases against attorneys and accountants begin and end. Okay, breach of contract. When an attorney or an accountant takes on a client, it can create an express contractual relationship, which means that we have a contract that we sign with each other. I think this is particularly true for an auditor working, or for an appellate attorney who's doing long-term expensive work. It's probably not as common for a simple traffic ticket or a quick tax return. But when you take on a client, very often you have a signed document, and that document is, this is what I'm going to do for you, this is what you should expect, this is what I'm going to charge. Now, as an attorney, I found those very, very, very useful because, one of the things is it spells out how much money is going to be paid, what you're going to pay me, when you're going to pay me, how you're going to pay me. So there was never, well, you never told me this. Here's our contract. Here's where I said I would. Or I try to do something and my client says, that's not what's called for in the contract. We look at the contract, the client's right. So contracts are really important because they frame, and we've had several chapters on contracts in this test, they really frame our duties to each other. Now, what can happen, of course, is you can fail to live up to your requirements under the contract. So let's take an accountant here. Let's suppose you retained an accountant to file your taxes. And April rolls around, and in a regular year, maybe not this year, but April rolls around, and the filing deadline comes and you don't get your taxes filed. So you have to scramble, and at the last minute you hire another accountant who charges you a lot of extra money, who manages to get your taxes in. Yay. So your lawsuit is, I had a contract with accountant firm ABC. They were going to file my taxes. They never filed my taxes. I had to go out to accountant firm DEF So first I had that expense. Then because I filed late because of them, I had to pay interest and penalties. So those would be reasonable and foreseeable losses arising from the breach and the breach of contract. All those would be part of, after your cause of action, that's what you would sue for. Negligence is a little different. Now negligence, although it can be related, you can say that through your negligence you breached the contract. So these aren't absolutely distinct areas. Pardon me while I sip my coffee. But for negligence, you've got the three requirements and the unity of the three. So what are the three requirements? And we had a chapter on this when we talk about negligence. First, you have a duty. So let's go back to our accountants, since the first part of this chapter is a lot about accountants, not attorneys. Or we can talk about attorneys at the same time. The accountant said he'd file the taxes. The attorney said he'd represent you in the speeding ticket. That was their duty. The accountant didn't file the taxes. The attorney didn't show up to represent you. Now, the injury. Since you didn't file taxes, you wound up paying penalties and interest. Since the attorney didn't show up, you wound up being found guilty and had to pay more money. What you have to do to succeed in negligence is show that these three things that are approximately related, that the breach of the duty related to the injury. If you change one of those, if you say there's no connection, then it destroys the claim of negligence. Look at the attorney showing up. Let's suppose that you actually were speeding, that there was no question, that the fact that it didn't show up didn't change the fact that you were going to be found guilty. Let's suppose that you owed no taxes, and the fact that it didn't file the taxes didn't create any liability. Well, in both those cases, one, for the attorney, there's no new injury you suffered. You were going to suffer it anyway. Or for the accountant, you didn't suffer any injury at all, so there'd be no negligence, even if they didn't do their job. It might be a breach of contract, okay, but not negligence. Now, most of the time when we talk about negligence, we say the attorney or the accountant didn't meet the standard of care required. And typically that standard of care is established by that professional's organization. And we're going to look at the accountant ones first in a little bit. So we look at what care you should take, what knowledge you should have, what judgment you should exercise. So the accountant's duty of care is, now generally accountants are expected to have the skills of an ordinary and prudent accountant. Sometimes in the law we have what's called the reasonable man standard. This is really the reasonable accountant standard, if you will. It shouldn't be account, it should be accountant. I'll change that in the final slide. Professional organizations for accountants, like the American Institute of Professional Certified Accountants, have established standards for accountant and auditing. So we have what are called generally accepted accounting principles, GAAP, and generally accepted auditing standards, GAS. If an accountant didn't meet these two standards, we would say that they breached their duty here. They were negligent. So violation of GAAP or GAS is prima facie evidence of negligence, even if even meeting this won't necessarily get you out of it if the state has a higher standard. So GAAP or GAS may say this is best practices, this is what you have to do as an accountant for auditing. You have to file A, B, C, D. But F, G, H, I are optional but recommended. Well, your state registration for certified accountants might say, no, you have to file A, B, C, D, E, F, G, H, I. You have to do all that. If an accountant is specialized, and this is pretty common that accountants will specialize maybe in auditing, maybe in taxes, then we can expect a higher standard in that field, a higher level of care than the regular accountant. All right, discovering fraud, and this kind of relates to this. Accountants are not required to discover every problem or defalcation, which is, for example, embezzlement. But if fraud continues because the accountant is negligent, they may be liable, particularly for future losses. So if an accountant doesn't find fraud, he's certainly not liable for the fraud that occurred before. But if he doesn't find it, and it goes on and more losses occur, then there may be liability there for the accountant. All right, let's talk a little bit about audits. Audits are a systematic inspection by analysis and test of the business's financial records. It's really giving you a snapshot of the health of that business. All on one side its liabilities, all on one side its assets. And after this audit, the auditor will issue an opinion on the stated financial position of the company. And generally what they issue is they issue an opinion letter. Now this can have disclaimers in it. It could say, well, part of the evaluation of this liability took place about this piece of copyrighted material or this piece of asset, and I had to rely upon this, this, and this. So it may have qualifiers in it. It's not intended to discover fraud. Audits don't necessarily discover fraud. They often can, but sometimes fraud can go on for decades. There was a case up in a town in, I believe it was Ohio, where the business manager stole for like 20 years until it was discovered. Sometimes businesses want an unaudited financial statements. Now sometimes audits are expensive because they're time consuming and the accountant is really putting his reputation on the line. So sometimes, as opposed to paying a much larger fee, a business might say, well, just give me an unaudited financial statement. It's one that's really not as backed up. The accountant's still going to have some liability there, but audit and will take a unaudited financial statement, although there's still going to be some liability there for the accountant. Okay, defenses to negligence. The big defense, of course, is claim there's no negligence, that you didn't do this, because sometimes people accuse you of negligence, but it's simply not true, particularly if a layman accuses a professional of negligence. Now, if another accountant does, another attorney does, that's a different standard. You can claim that yes, there was negligence, but there was no injury, or that the injury that was suffered by the client isn't related to the negligence. Because let's be honest, both attorneys and accountants are humans. They're going to make mistakes, but it doesn't mean that every mistake leads to injury. You can also claim that, and this goes to the doctrine of whether you're in a comparative or contributory negligent state. Yes, I was supposed to file your taxes, but you never provided me with the resources to do so. You didn't give me receipts, you didn't give me your W-2 access. Therefore, you were also negligent. If I was negligent in not filing on them on time, you were negligent in not providing it. So there's a comparative or contributory negligent defense there. All right, what about the attorneys? Now, again, there is the nationwide group, the American Bar Association, and then every state has a state bar association, so there's the North Carolina Bar Association. But there's also a third organization in North Carolina, the North Carolina State Bar, and that's what licenses me as an attorney. And the state bar really expects that every attorney is a reasonably competent practitioner. They recognize there's got to be variations. There are really good attorneys and there are not so good attorneys. They also recognize that there are specialties and subfields, just like the auditor is a subfield of an accountant. There are attorneys who are appellate attorneys, they handle appeals, or there are tax attorneys. So if you held yourself out as one of those experts, we can require or establish a higher standard of care there. All right, misconduct. Generally, any act that relates to honesty and trustworthiness is misconduct. Minor manners like speeding tickets, not so much. Even serious ones like DUIs or drugs, they may be or they may not be as serious. But if you committed perjury, that would be a serious attack on your honesty. People make mistakes. Sometimes those mistakes are labeled as criminal. Simply because it's labeled as criminal does not mean that it is really a breach. But there are, and this is sadly somewhat common, breaches of fiduciary and pecuniary relationships. Fiduciary relationship is the relationship of trust that underlies all attorneys, accountants as well to some extent. And pecuniary is handling of money. So very often, one of the primary reasons an attorney gets disbarred in North Carolina is they commingle funds. So probably the most common reason that attorneys, and I dare say probably accountants, although I'm not as much of an expert, a bit of a caveat there, would lose their license or their certification, would be financial or pecuniary irregularities. Attorneys very often, if you think about it, every case has a winner or a loser, which means 50% of the time, one attorney's on the side of the loser. If you could always sue the attorney who lost, then there would be constant malpractice this way. So simply losing is not malpractice. Malpractice exists when an attorney fails to exercise reasonable care and judgment. Mere injury to the client, mere conviction is not enough. You have to show that my actions caused that in order to bring a lawsuit against me. And, a lot of the time, what an attorney is really trying to do is to limit damage, not to win. It's great if your client is never convicted of a crime. That's the best possible scenario. Actually, the best possible scenario is they're never charged with a crime. The second best one is they're never convicted. The third best one, and the most common one, is they're not convicted of what they're charged with, but they are convicted or plead to or settle a lesser charge, a plea bargain. So if we look at criminal cases, for example, the vast majority of criminal cases, 90+%, are handled by plea bargains, which means you accept guilt but a lesser penalty. All right, liability for fraud. Now, what's fraud's idea? Well, fraud says you misrepresented a material fact. So basically you lied. And you lied with the intent to deceive the other party. Sometimes you tell a lie, a little white lie as it's called. You're not doing it with the intent to deceive the person. You might be doing it out of a kindness. But you do it with the intent to deceive that person. And then if the other person actually relies upon it, and that reliance was reasonable, now you have the core of fraud. So actual fraud is when an accountant or an attorney lies with the intent of reliance, and that reliance was reasonable. Slightly different than that is constructive fraud, when the professional lacked the intent to misrepresent, but was grossly negligent. So sometimes you tell a lie or a falsehood and you know it's false, that's actual fraud. Sometimes you tell a lie, you didn't know it was a lie, but you should have known it was a lie because you were grossly negligent. You weren't just you didn't read one opinion that was in the back of one text 100 years ago. You didn't read basic constitutional law. Okay, I've been talking a lot about the attorney or the accountant being liable to the client. And traditionally, professionals owe duties to their clients, not third parties. So quickly, attorneys, again, I'm more familiar. If a husband hires me to represent him in a speeding ticket, and he winds up getting convicted, and the wife is the one who earns the money in the relationship, and she winds up paying a higher bill because of it, can the wife sue me? Well, the general rule is no. Who did I represent? I represented the husband. That is called privity. That is the original relationship, sometimes we say the original contractual relationship, between the two parties, the buyer and the seller, or in this case, the professional, attorney/accountant, and client. People outside of privity don't have the right to sue. That was the general rule. Now, the first modifications was to the idea, well, parties that are in near privity might have to accept it. Now, some people, some jurisdictions, but it's only a minority of jurisdictions, have said anybody that could reasonably be foreseen to use any report, and this is particular for accountants, have liability. So let's take the financial statement. The financial statement is between the company and the accountant. The general rule is, right, the firm could sue the accountant, but anybody that relied on it outside the firm couldn't. Well, slowly people said, well, if that was required to be presented to the SEC, and the reason it was filed was the SEC required and the SEC relied upon it, they were a party in near privity. But what about someone who decides to invest in a company because they see a copy of the auditing report? Well, that would be a much larger expanse, any reasonable foreseeable. The current one, majority, is accountants are liable to foreseen or known users of their reports. Anybody that you could foresee, anybody you know is going to use your report, you can have liability to. What about attorneys? And I'm going to talk about a case at the end. I'm going to tell one of my stories because it actually happened in my neighborhood about it. But the common law did allow some liability, but generally I'm not liable unless I commit fraud or malicious conduct. And this is really the whole idea that the attorney-client privilege is almost absolute. I know things about people that my wife knows that she has no idea about, because when I worked for these other people, they get absolute silence, absolute confidentiality. And because of that, we say, since we're going to say that there's this absolute confidentiality and that confidentiality belongs to the client, we're really not going to expand privity for attorneys as much as we do for accountants. All right, well, let's talk about one of the scandals that hit the United States in the early 2000s. And this really came out of Enron and a few others. But what had happened is there had been a series of audits. And it turned out that some of the initial auditing was done by I think it was called the Big Eight back then, if I'm not mistaken, accounting firms. And a company like Enron would come and they would say, we'll pay you $100,000 for an audit of our firm. But if we like you, if we get along with you, we're going to hire you to do all our accounting for $10 million. So all of a sudden, these accounting firms that were having to publish public financial statements, $100,000 to do that, $10 million to become their accountants. Let's not be too critical about our financial statements. And this led to a series of scandals where financial statements couldn't be relied upon because basically the accounting firms had been captured. They really weren't independent. So in the wake of these, Sarbanes-Oxley created the PCAOB, or the Public Company Accounting Oversight Board, which is under the authority of the Securities and Exchange Commission. And it really tried to mandate that auditors would be more independent, that they would disclose any conflict of interest, and try to make the financial statements more trustworthy. They also created liability for the chief financial officer of corporations and things like that. The Public Company Accounting Oversight Board really seeks to regulate the larger corporations. And if you have over 75 million in assets, it's a stricter standard. It also required that working papers, basically the information behind the audit, is kept for up to 7 years, up from 5. What about the Securities and Exchange Commission? Now remember, in one of our last units we were talking about the Securities Act of 1933, which really had to do with new stock being issued, and 34, which had to do with stock being traded. So there's two sections here that impact accountants. Section 11 requires accountants to exercise due care and diligence in any registration statement, and it places the burden on the accountant to verify corporate statements. Section 12.2, accountants are liable if they participate in the preparation of materials for a fraudulent sale or issuing of new securities under the Securities Act of 1933. 1934, we have Section 18 and then our old friends 10b and 10b-5. Section 18, you're liable if a buyer got false or misleading statements when the accountant involved prepared an application, reports, or registration. And 10b, 10b-5 waives the idea of privity for any sort of stock transactions. Accountants have very broad liability for any violation of the SEC here. Private Securities Litigation Reform Act came down in 1995, basically said it is a crime to aid and abet any violation of the 34 Act. If an accountant discovers fraud or an illegal act, they have to disclose it. First, believe it or not, they have to disclose it to the company, because it may be not the company doing it, but merely an employee like the chief financial officer or the chief executive officer. They have to tell the Securities and Exchange Commission, they have to tell the auditor committee, which should be quasi-independent. And accountants can be liable for proportional damages that he is responsible for causing. All right, so they also have broad criminal liability for violation of security laws and obviously for tax laws, and those tax laws can be very extensive. It can run between $100,000 to $500,000 for corporate returns and up to 3 years in jail. And if you'll turn to page 904 of your text, 15th edition, you'll see statutory law liability of accountants and other professionals you could look at. Okay, let's go back to attorneys. One of the things that I would tell clients when they sat in my office was that I represent them. I don't represent anybody else. I don't represent their wife, their mother, their kids, nobody. So, sometimes when I was doing a will or something, if I had a married couple, I didn't meet with them. I met with them together, but I would send one out of the room, and I would talk to the husband or the wife, and I would say, okay, between you and me, and this won't affect anything, and your husband or your wife won't know, is there anything I should know that will affect the will? For example, is there a child they don't know about? Is there a marriage they don't know about? Is there a divorce they don't know about? Is there something that could impact the estate? You tell me it goes no further, it has no impact, but we need to know. And sometimes they would say, yes, I was married and he doesn't know, or yes, there's a child and she doesn't know. The general rule is that privilege is absolute. It is enshrined in every state law. Every state has a law that says there's attorney-client privilege. And I may not disclose what the court, even if a court orders me, I can't disclose what went on. And the client alone has the power to waive this privilege. So I'm going to tell you an interesting case coming up in a second. But basically, North Carolina says, in order for this privilege to exist, there has to be an attorney-client relationship. It simply can't be you and me talking in a bar and you find out later I'm an attorney. You say, well, that's privileged. The communication must be made in confidence, which means it's generally made in private or in front of only people or the employees of the attorney. The communication should relate to a legal matter, not like sports betting, and the client owns the privilege and they alone may waive it. So I'm going to talk now about a Raleigh case that framed this nicely, and I'm just including this kind of as an aside. So there was this doctor, he worked I believe for Glaxo, his name was Eric Miller, Dr. Eric Miller, and he was poisoned. Now Darrell Willard, not Miller, but Darrell Willard contacted a North Carolina attorney. The attorney's name was actually Richard, but everybody calls him Rick Gammon. Now, Darrell Willard, interestingly enough, lived on my street. He lived down the street. What was going on was that Dr. Miller's wife, whose name was Ann, was having an affair with Darrell. And together, they conspired at first to poison a beer that Dr. Eric Miller drank at a bowling alley, and later they put arsenic into his feeding line or IV line in a hospital. So they were having an affair. Ultimately, the poison kills Dr. Miller, so he's dead. Darrell Willard goes to see Rick Gammon. He says, yeah, I killed him. Do you think I'm going to get charged with murder? What should I do? And Rick Gammon says, yeah, you are going to get charged with murder. You used arsenic, which is a dumb poison to do. There's lots of traces of it. You're going to get charged. So he goes home on the street I lived on, and he kills himself. Now, I want you to notice one thing here. There were 2 women and 2 men involved. The 2 people who wound up dead were the 2 men. Now, Mrs. Yvette Miller, who is Dr. Miller's spouse, claims that she inherited the right to waive the privilege of confidentiality, and it wasn't clear at all that that was true. Gammon declined to talk, and he basically, the case went all the way up to the North Carolina Supreme Court. And at first, Gammon said, I won't say. Finally, the Supreme Court of North Carolina says you have to. Eventually, he gave a deposition. It turned out in the deposition that, yes, indeed, Darrell had said he killed him. And Ann Miller then entered a guilty plea after that. The reason I mention this is that for a while there, a dead man, his testimony that would have convicted a murderess, was not admissible because of attorney-client privilege. And it generally would not have been unless the Supreme Court of North Carolina had intervened. That's how serious confidentiality is. I'll leave you with this point. Your mother, your brother, your child, you can tell them anything, they can be compelled to testify against you. But so long as you're alive, if you've talked to an attorney and you just consulted him about a criminal action in the past, whatever you told him is absolutely sacrosanct and protected. All right, on that happy note, just remember that for accountants, there is no confidentiality. There's no special rights. North Carolina doesn't recognize it. So what you tell your accountant, not as protected as what you tell your attorney. All right, well, that keeps us right at about a half an hour. Have a good evening. When you're ready, click on the next